Malcolm Burrows, Principal of Dundas Lawyers. Dundas Lawyers is an award-winning corporate, technology and intellectual property law firm that also passionately litigates in these areas of practice. One of the telltale signs of an impending shareholders dispute occurs when those with access to information, such as the directors or the majority shareholders, restrict access to this information to other shareholders and directors in the business. In this video, we'll explain at a high level what information can be obtained about a company, how it can be obtained, and what could be done if your attempts to obtain that information fail. Companies hold a range of information from customer records through to governing rules and financial information. Not all of this is easily accessible or available, for that matter, to all shareholders. Typically, a shareholder will have rights to obtain a copy of the company's constitution, pursuant to Section 139 of the Corporations Act, and copies of financial reports pursuant to Section 293 of the Corporations Act. A company's constitution usually contains the rules and procedures that relate to voting rights at directors and shareholders' meetings. However, there may also be a shareholders' agreement or other what we call governing documents. Among other things, this information may be able to be used to access what can be done about the acts or omissions of directors and the mechanisms by which those actions can be taken. The financial reports provide information about the financial position and performance of the company, and may also provide insights into the major contracts which the company has entered into. Shareholders have statutory rights to obtain a copy of the company's constitution, as we've said previously, and that right must be provided within 7 days of receiving a written request and any payment for any associated fee, which is normally nominal. Whether or not a company is required to provide financial reports depends on the circumstances. A small proprietary company, being a company with less than 50 employees, having a revenue of less than $24 million and gross assets of less than $12.5 million, must provide financial reports to shareholder who holds at least 5% of the securities on issue. If all else fails, a shareholder can seek an order of the court for the company to provide the requested information pursuant to Section 247A of the Corporations Act. An order of the court can grant access to all documents owned or controlled by the company, including the financial reports. To be successful in such an application, the shareholder must prove that the application is made in good faith and for a proper purpose, which typically arises when the shareholder is able to identify a corporate governance issue, generally known as a malfeasance or a wrong. So if you're faced with a potential shareholder dispute and you're looking for a commercial savvy firm to advise on a shareholder's dispute or a potential breach of director's duties, please don't hesitate to call me on 3221 0013 for a confidential and obligation-free discussion. Thanks for watching.